of the IPOA Act. Your Honor, on 8th day of June 2025, IPOA learned the death of Albert Ojwang while in police custody at Central Police Station within Nairobi County. Your Honor, the authority immediately initiated investigations to unravel the circumstances surrounding the gruesome death of the deceased. Your Honor, so far, our preliminary investigations have revealed that the deceased was arrested following a complaint by the Deputy Inspector General of Police.
Your Honor, all that the witness is saying has been said. You can only adopt the proof verdicts. Because unless there's any other crucial information.
That's another, Your Honor. That's okay.
Yeah, I was of the view, but just give a highlight, not necessarily going paragraph by paragraph, just a highlight, and then we can adopt it. Just a brief highlight.
Okay.
You okay with whatever you've said so far?
Yes.
And whatever you've averred in the affidavit, yeah? So we can proceed with the cross-examination?
Yes.
Is that okay? The other from the state?
That's actually not that.
Okay.
They can proceed to examine on the affidavit.
Thank you. Your Honor, I'll be asking the witness, Mr. Jibril.
So, Mr. Nelson, maybe just for housekeeping in good order, how many of you will cross-examine him?
3.
3. You, yourself, and who else?
Me, what? Kangai.
So only 3 of you? From
Yes,
the
we'll cross-examine him. The others will submit.
I think that is all.
Thank you. Mr. Jibril,
Yes, Your Honor.
can you confirm your position at IPOA over this matter?
You are asking my rank?
Yes. That's a matter.
Your Honor, as indicated, I'm a senior assistant director in investigations.
And confirm that you are an investigator.
Yes, Your Honor.
Are you an investigator in the purpose and the name or position of the National Police Act?
IPOA Act.
Under IPOA Act. And under IPOA Act, is it true that you have still arrested powers?
Yes.
Under which section?
Your Honor, Section 7 of the IPOA Act and Section 7 of the IPOA Regulation Act actually gives me the powers, privileges, and immunities of a police officer.
So Section 7. And which section?
Both Section 7 in the IPOA Act and Section 7 of the IPOA Regulations Act.
Gives you the powers as that of a police officer.
Yes, Your Honor.
And in this matter, you are now actively participating pursuant to those provisions as an investigator.
Yes, Your Honor.
Thank you. Are you well conversant with the law?
Depends on which area you want to ask.
Are you, you know, some of us went to teach, then we became lawyers. Some people are mad about that. Do you have any legal training?
Yes, yes, I do.
Could you refer the court to your legal training?
I'm an advocate of the High Court of Kenya.
Thank you. You are an advocate of the High Court of Kenya. Look at the Criminal Procedure Code, Section 386, as an advocate of the High Court of Kenya. Could you be given it?
Your Honor, we'll have an objection.
I've not asked the question.
We can see. Your Honor,
I've not asked a question.
Your Honor, at least should I be allowed to make the objection?
Yes.
Of what?
Let me just object, then you
No,
can...
no, no, no. You wait until I ask. I've just told to look at it. It might be just to admire it. Allow me to ask.
Your Honor, we'll be requesting the court to
Mr. Nomad,
Yes.
let's hear his objection.
Okay, all right.
That's right.
Yes, thank
Your
you.
Honor, the witness before the dock
Yes.
has come here on the basis of his affidavit on the factual matters. And that explains why the defense requested that my colleague, my learned senior, does not go into the facts. Section 386 of the Criminal Procedure Code, or whatever provision of the law, is a matter of law. And Your Honor, the objection again goes into the earlier intended preliminary objection, which we have had sight of, where the argument, in a sense, is that this matter, now we have had a copy, although it's not filed, this matter should have been the subject of an inquest and not a miscellaneous application. So that because we are alert, the defense should not try through the window to bring in a preliminary objection which they admitted not to have filed. But more importantly, that this is a witness of facts, not a witness of the law. We can deal with the law between the lawyers. Thank you.
That's Your Honor. Is the law a fact? Yes. Is he in a court of law? Yes, he is. Is he an advocate? He knows it. What is it that they are fearing and telling us they are coming through the window? If we come through the window, please respond and throw us out of the house.
There is a submission.
You know,
I've not asked any question. I've only told you to look at that section.
but just for guidance, you know, it's a matter of evidence on the facts. It's an affidavit, for heaven's sake. So let's leave it to the facts of it.
After I've asked the question,
Yes.
then that is when an inference can be done, whether it's a question of law or a question of fact.
All right.
I've not asked what. I've only told you, look at section 3.
Your Honor, just one more thing. The reason we requested the defense at the very onset to inform us of the paragraphs is that the cross-examination is limited to the contents of the affidavit.
True.
There is no reference to section 386 in the affidavit. They cannot go to it because it is not a matter of fact. If you pointed to us the paragraph looking at section 386, which we referred to, there will be no objection from our end. But because affidavits are leadings of fact, we plead with you to reject the invitation of the witness to look at section 386 or any other provision of the law. Thank you.
I think he was referring to section 386.
Yeah, I just only
So
told you to.
let's not convolute it. Let's limit. It's an affidavit.
Purely, I've not asked any question, Your Honor. If we only had what I've asked you, and I ask a question of law, then the court can stop.
Okay, then proceed and ask.
Let him have that. Let him look at what.
But you know, once you point it to the law, then it means
No.
it's a point of law.
And that exactly is our objection, that we can't refer to the law. That is, maybe, see, a counsel is not understanding our objection.
Very well.
Maybe
All right.
counsel, maybe rather than asking him to look at the law, why don't you put the questions to him?
Correct.
All
Just
right.
put the question
All right.
rather than us going
Very
to
well,
the.
very well. From your affidavit, confirm the place of death of the late.
Central Police Station cells, Your Honor.
Central Police Station cells. From the IPOA Act, provide the mandate for you to investigate somebody dead in a police cell.
Yes, Your Honor.
Read, show the court. Because you have confirmed the scene of death is at the police cell. Which mandate gives you that power? Let him answer.
Your Honor, we are still objecting. Counsel is still taking the same route.
He came under the act. You know, section in this miscellaneous application, paragraph 3, they must have said under which mandate they are coming before this court.
Don't give him a
And this is a witness.
This is our witness now.
He's not an advocate. Let him come in front of you. Let him not be given answers.
No, Your Honor. we plead with our colleagues to just remain respectful. We know that they are very good people. Let us maintain the decorum. What we are asking is, as the court has suggested, put the law to the witness. Don't ask the witness to follow the law.
Very well.
We do not mind if you read the law to him and ask questions.
Read paragraph 3 of your yeah.
Please read for me so that I can answer.
No, you read it. I didn't write it.
Which one?
Paragraph 3.
That investigations by IPOA are pursuant to Section 6A, 7.1, and 25.1 of the IPOA Act.
Is that the law?
Yes.
Is that a fact or that is the law?
That is a fact as per this affidavit.
That's what I'm saying.
Yes.
You have quoted the law. True.
Yes.
Therefore, it is not wrong to ask you a question of law because it is yours in your affidavit talks the law. Give me the law that gives you mandate to investigate a person who dies in a police cell. But it's simple.
I have indicated the sections 6.1, 7.1, and 25.
Just tell the court.
Yeah, Honor, I have indicated section 6A, 7.1, and 25.1 of the IPOA Act.
Could you kindly read to the court those sections that gives you that mandate? The IPOA, just read to the court those sections for the benefit of the whole one. We don't work for IPOA.
Because we did not anticipate that a witness of fact will be made to read the law, we didn't carry a copy of the IPOA Act. If they insist that they want to read it, let them just read it.
Wait suffers from selective amnesia when he is cornered. It is there. On any phone. Just read it. Read the section. 6, you read.
Okay. Section 6, Your Honor talks about functions of the authority.
Yes.
Here means IPOA.
Yes.
That the functions of the authority shall be 6A, investigate any complaints related to disciplinary or criminal offenses committed by any member of the service, whether on its own motion or on receipt of a complaint, and make recommendations to the relevant authorities, including recommendations for prosecution, compensation, internal disciplinary action, or any other appropriate relief, and shall make public the response received to these recommendations. Shall I continue?
Yeah, anywhere where the death of a person in police, specifically, that's all. My question is specific. Can we allow the witness to read?
This is a question.
Sorry, Your Honor.
Before you even say that, this is a question that has been put to this witness. It is about what he has said in his affidavit. He is being asked to justify why he is here and what gives him the powers. The state, who has not been asked a question, can now stand and start giving him answers or start supporting him, getting answers.
Mr.
Yes.
Do you have
Yes, Your Honor, I just wanted to indicate. Section 6 has been referred to in the affidavit. The witness has been asked to read, he has read the affidavit. The witness is being asked about the law supporting an action which is not in the affidavit. That's where the difference is. The witness is saying that Section 6 allows us to do A, B, C. But counsel is asking, does the law allow you to do A, X, which is not in the affidavit? We believe that by him having cited to us the paragraphs he would ask questions on, asking the witness about the law allowing you to investigate deaths in cell, which we have not referred to in the affidavit, is going outside the affidavit. But we would be guided.
So it's a bed of contention. So let him answer. If it falls under the ambit of that section 6, let me just say
That's right. That's right.
Under that provision of the law, and let's leave it as that.
That's right. That's right.
And the question we are here about is specific to death inside a police cell. And that is all I'm saying. If he says that section, then the court will go and make a ruling out of it. That's all we're asking. In relation to death in a police cell.
In police custody.
It's not you to set my question. I've asked you my question. You can't set a question and answer yourself.
So Mr. Jibril,
Yes.
If it's not there, it's not there.
The question is, do you have the powers to investigate?
We have powers to investigate death that occurs under police custody.
And that's good enough.
Yes,
That's
and
good.
custody includes
The
cells.
court has gotten what we have asked. The question has been answered. We do submissions on it. That's all. Let's go to paragraph. Paragraph 7. You have paragraph 7?
Yes,
Read to the court what that paragraph says.
Your Honor, the paragraph says that the respondent was arrested on 13th June 2025 by DCI officers and subsequently handed over to IPOA and was later booked at Langata Police Station via OB 50-13-6 of 25 at 18:05 hours.
The DCI officers arrested him at what time, according to your there?
He said around 3.
You read exactly what you're saying.
I've not indicated the time.
That's I'm asking.
Yes,
It is not indicated when the DCI officers are arrested.
yes,
Where did they arrest?
at the DCI headquarters.
And the nota Eldoret
No, Your Honor.
found that the accused was not arrested at Eldoret. The respondent.
According to the officers who handed over me to Mr. Talam, the officers informed me that they arrested him at the DCI headquarters.
Thank you. I'm putting to you that IPOA released a false information to the public that he was arrested in Eldoret en route to escape to Uganda.
That is not in my affidavit.
I'm saying what is in social media is that the respondent...
Your Honor, I can only answer what is in on this affidavit.
Sorry, Your Honor.
Let's not digress to those issues.
Yes.
Yes.
Let's proceed on the question of arrest. Are you aware the Director of Criminal Investigation, my friend Mr. Mohammed Amin, said the respondent is a person of interest?
That is not in my affidavit.
That's why I said, are you aware? If you are not aware, you are not aware.
Counsel, please ask me what is in this affidavit. I'm not going to, Your Honor, I'm not going to answer anything outside the affidavit.
I put it to you that based on the DCI mentioning the respondent, on that day at 2 p.m., he presented himself to the DCI headquarters in the presence of his advocate, Juan Keton. Were you aware of that?
If you said so.
And the DCI authorized these officers together with the advocate to present the respondent to IPOA headquarters.
Your Honor, we have said time and again.
I'm
That,
putting it to you.
please,
You don't need to answer.
please answer me ask me what is in my affidavit. Let's stop charges, Counsel.
Counsel, I've only put it to you, I've not asked you the question.
Is it in my affidavit? The question I'm asking to you is it in my affidavit?
The
The answer is
benefit
no.
of the court, I'm putting to you, then I'll ask you where you are saying you are arrested.
Your Honor, I will decline to answer anything which is not in my
I've not
affidavit.
asked. I've not asked.
Then please ask.
I put it to you that the officers handed over the respondent to IPOA in the presence of Mr. Keto. As I put it to you, for the record purposes.
Samson Talam was brought to IPOA head office by DCI officers.
And he did record a statement at IPOA in the presence of his advocate, Juan Kiprono. Who is it?
Is that in my affidavit?
I'm putting it to you, counsel. You are a counsel. When it's a question, I'll ask you a question. I'm
Please-
only putting it to you
please ask
for
me
knowledge
questions.
purposes. So now, if those are the facts, look at the paragraph you said he was arrested. Paragraph 7. Now I'll ask you questions from there. Read.
I have read and read. What is the question, please?
Cool your temper. It's a long day.
No, it's a long day, yeah? It's okay. It's okay.
The state is rich, it can bring water.
Yes.
For both of us and council. It's a long day. Can you confirm that paragraph 7 is not true, that he was arrested by the DCI officers?
The respondent was arrested by DCI officers after he presented himself and brought to IPOA.
Do you have any evidence material to that effect? I've given you the scenario the way it was.
No. The fact that he was brought under the escort of DCI officers means he was arrested and brought to IPOA office.
The court has taken that. Let's go further.
So, Your Honor, I think this may be my last objection. We hope that counsel is not proposing to court that he has an alternative set of facts which the court should take note of, because counsel is not a witness. If he wants to give us his alternative facts, we would expect an affidavit so that we also put him on a dock and cross-examine him. Until then, the only factual matrix we have is the one given by the witness before court.
The only way to prove our falsehoods is by bringing facts that are truthful. The affidavit is full of falsehoods. We are putting exactly the scenario, and your witness has not recounted any.
So, sorry. Your Honor, I am a believer on the law and procedure. What I understand by the law of affidavits is that a person cannot give us factual matrix, especially a lawyer or an advocate, from the bar. Right now, we have affidavit evidence given by this officer. We are having an alternative set of facts, which may be true. We have no reason to doubt it. But until we have an affidavit, all that is telling us is, I put it to you. And we hope it does not go to evidence.
Just to allay your fears.
Yes.
The evidence that I'm documenting is from me.
That's right. Thank you very much.
Not from Mr. Johnson.
Thank you.
Because as we put it rightly, he's not giving evidence.
Correct.
He knows the procedure.
Thank
That's
you.
why.
He's a teacher of the law.
Yes, thank you. And that's why I told you, Wiki now is mature to be a judge of the high court. Thank you very much. Let's proceed, Your Honor. Paragraph 9.
Yes, Your Honor.
Paragraph 9.
Yes.
You have said what? About the position of the OCS?
That the respondent at the material time of the incident, he was officer commanding Central Police Station, exercising command of the Central Police Station, hence persons of influence, and has capacity to interfere with the ongoing investigations and likely witness.
Do you have any evidence to show that he was in full command of the police station?
As an OCS, that is...
I've asked a simple question. It is either you have it or you don't have it. Do you have anything, either duty roster or something showing he was on duty or in command?
Your Honor, what the advocate is asking is that you are the presiding magistrate here. Do you have the power over this court? I mean, once you are an OCS, you have got a power over that station. Come on, counsel.
We have agreed that you don't have it. You are looking for it. Let me put it forward. And let me put it to you.
And Your Honor, just to answer also, whatever evidence that I had, I have put as an extra. Anything else which is not here is purposely done to safeguard, first of all, the integrity of the investigations. And they will be provided at the most relevant time. I'm well aware that this will not be the forum where those charges will be preferred. Yes.
So I've asked a simple question.
Yes.
Among the annexures,
there are none.
You produced an annexure showing he was in command of the police station at the time the offense was committed?
I recorded his statement and he confirmed that at the time of the incident he was the officer commanding station at Central Police Station in the presence of his lawyer. I have not attached in this affidavit.
Simple. The answer is clear. You have
Yes.
not attached. All that's what you are looking
Yes.
for. It's not attached there.
And maybe to answer your question, any other attachment that you might ask is not there, save for the OB extracts,
Just don't go. And you are a lawyer. When I say I put it to you, don't respond. I've not asked any question.
You're putting.
Then why are you putting in the first place?
Yeah.
Why in the first place?
You can put it there. You can put it all over.
Really went to law school.
So
and that is-
that's if you know what answers those questions that you're putting.
I
You're
know.
putting a lot of putting in.
Yes.
We have our own label here. Allow us to proceed. What is relevant, record. What is not relevant, leave it. I put it to you that the police station and the deputy was in command as an OCS.
That is not in my affidavit.
And I put it to you that the OCS was never near Central Police Station.
That is not in my affidavit.
Thank you. The world has had its own. Let's go paragraph 15. On the question of him likely to plan. You there?
Yes.
We have agreed there is no any material.
Yes, nothing attached to
Let's
this.
proceed.
Okay.
Paragraph 10.
You go back.
Oh, I asked you paragraph
15,
15.
yes.
I'm going to paragraph 16, sorry.
Okay.
Still no material attacked. It's either very serious material you have kept, no material attacked.
Yes, Your Honor.
Thank you. Paragraph 17 about the CCTV.
No material attached, Your Honor.
Thank you very much. Paragraph 18,
No material attached.
no material attacked. Paragraph 17,
Come on.
I've gone back because there's a question I want to ask.
Yeah, please ask.
You have said about the CCTV cameras. Do you have possession of the scene of crime as of now?
No.
Who is in possession of the scene of crime?
The scene of crime was processed and released. Remember, that's a police station. You cannot hold a station as a crime scene for a very long time. So we have released to the relevant authorities.
Is that on off? Because I was there yesterday. It's not true that the scene of crime has been released to the police.
Then
Is it still a scene of crime, or it is non-operational police station?
that question is not. It's not in my affidavit.
You've run very fast. Do not lie that is. So you cannot. There's no material to show that.
Nothing attached, Your Honor.
Paragraph 19. You've read it?
Yes, Your Honor.
And 21, they are the same.
What's the question? No material attached.
There is no material attached.
Yes.
That is very, very critical to us. Paragraph 22. I still ask you this question about the blue code of silence.
I will refer you to the High Court decision.
Tell the court. This is a lawyer. He knows the court decision.
Court of Appeal decision.
Give the court that decision.
In the Titus Ngamau case, 2020. It was a phrase coined by the judge who was dealing with that matter.
And I remind you, Cliff is the one who argued that matter.
Yes.
He'll face you over that matter.
It's okay.
He's the one who argued that matter. Cliff will deal with the blue code. Paragraph 23. You are now providing reasons as to why you want him to be detained for 21 days. True? From paragraph 21. 23.
Yes, Your Honor.
What is the reason you want to detain him in paragraph 23?
That we are yet to record critical witness statements.
Very well. Is his presence required physically when you are recording statements from other people?
His detention is required so he doesn't interfere with the witnesses.
About recording statement and interference are two things. Wakili,
I have responded to your question. The reason as to why I'm seeking that prayer is to have him detained so that he doesn't interfere with the witnesses.
Very well. Does he know the witnesses?
Them being police officers? The answer is yes.
Is there anything you have shown of any attempt to interfere with witnesses? Because, Counsel, you know very well, the authorities, the Sagari, Duarte Sagari, Cliff will ask you. The questions I'm asking is to prove, have you demonstrated by material your verdict?
Nothing attached.
Thank you. Important. Paragraph 24. What are you addressing?
That we are saying if released, his security is not guaranteed due to the public anger demonstrated by the case. I've just read what is in the affidavit.
Yes.
I'm saying that the gruesome murder of the deceased has elicited widespread public anger, and therefore, if released at this point, the respondent's security cannot be guaranteed.
Mr. Witty took us a lot about the case of Oscar Sudi. Heavily. Have you ever had a chance to read paragraph 32 of that decision of Professor Justice Joel Ngugi?
Not in my affidavit.
It's not in your affidavit.
Yes.
For the benefit of doubt, you are saying you want to detain him on two limbs. One, for the safety of his life. True?
Yes.
Do you have anything to show that his life is in danger?
Nothing attached.
Do you have anything to show that he is a danger to anybody of the public?
Nothing attached.
So it is an apprehension.
Yes, Your Honor.
Thank you. It is an apprehension. Lawyers swear to be court officers. It is an apprehension. And you are very aware that the National Police Service is the one mandated to provide security for everybody in this country, including the already convicted murderers. You are aware of that?
Not in my affidavit.
No. You will fail to be not understanding what I'm asking. I'm asking you this question. The duty to protect life and property falls under the police.
If you say so.
And this country is not a banana country where the rule of law has broken. So it is not right to say you are preserving his life in cell. And he pays taxes. Everybody pays taxes to be protected. And that it will be dealt with in the cases that I've talked about. Now, what other reason do you need him in cell to detain him for 21 days?
All I stated
What
in my
do you specifically want him to do?
All I have stated in my affidavit.
Is there any other reason we have not dealt with?
Everything I require, I have indicated in my affidavit.
Confirm you have his phones.
His phone.
His phone, you have it.
Yes.
And you are seeking this court. Did you have the court order to possess that phone?
I don't need a court order to possess a phone.
Do you need a court order to get access to the phone?
Yes, I do.
Where is the provision that does not allow you to have authority to possess?
It's a seizure.
Sure.
Wait, allow
Sorry, no. Yona, where is the provision that does not allow you? Surely.
Where is
You
the
are asking
provision?
for a provision which does not allow you. This is a negative provision, does not exist in our law. He should tell us the positive provision, and council can put it. He can continue putting it to him that this provision does not allow you, not the negative provision.
Maybe rephrase your question.
I'm rephrasing. You know, which has a problem is preparing for the judge. It's not keen to this matter. You need him 21 days for the sole purpose of granting access. Is it him who grants access or the court?
No, Your Honor.
Who grants?
I need the 21 days to complete my investigations.
I've asked a question specifically. Do you need my client in cells for the purpose of analyzing the phone?
I need your client in custody for 21 days to complete my investigations.
I've asked a simple question. Is there any role he's required to do in forensic analysis of our phone?
I'm not an expert in forensic analysis, so I cannot say.
So, your arguments are not based on any scientific, because you never consulted a forensic expert? It is you swearing 21 days.
Yes.
And I've asked you, should the court why 21 days? Why do you need him specifically?
Your Honor, the issue is not about only phone extraction. It's not only about phone analysis.
What else?
I have said to complete my entire investigations that entail so many things. Among them, what you have stated.
And lastly, you have already attached the order in your application. Look at it. We have an order. True. Makori, this is a competent advocate and witness. Let him answer.
No,
I have seen an annexure here.
Can I check, yes?
I've seen an annexure there. We were given an annexure that has. Is it yours?
Yes.
Or disown it?
No, it's ours.
Very well. Let me ask you the question. You are certain you are getting
It's a draft.
these orders?
Counsel, this is
No.
a draft. It's a draft.
Which is saying, is the office of the DPP or IPOA that gives the orders, or is the landed court? What is the import of you drafting an order? Is it a formality that in this court already you have decided, not the court decides? Who decides? I hope it ceases from being
I hope
the norm.
we can save time by admitting that the application was drawn by the office of the DPP. What we have annexed as an order is a draft order. It is not the first time today. Is it 18? It has been done since I was a law student at the University of Nairobi, where we do draft orders. The court can reject it. It's not binding on the court. So that we save time for counsel and his client. We
Which have only for good practice.
We admit.
Avoid doing the judicial work. Leave the courts to do their works.
So maybe Mr. Whitty, let's not delve so much on that here.
Yes.
I think what Mr. Whitty is saying is just practice that they have adopted from the DPP's end, which is not a good practice.
It is not good practice.
So let's leave it at that.
If I sat in that office, I wouldn't allow that. But I was chased. Thank you very much. Let me allow Mr. Kangai to proceed. Oh, sorry. You already said it.
You said
If an advocate is not allowed to talk, I will be stoned out. Put Mr. Shadrach on board. He has just left class to come out. He was teaching till he's late on the forum.
So, Mr. Katai, Mr. Shadrack.
They will release
Shadrack, we're just trying to put you in order. It should be a difficult one. After Mr. Shadrack, Mr. Keto will play his legal basis. Then I'll wrap up the application. I think if Umbeta and Mr. Unjui will be making a submission on that one.
Your Honor, with your permission, I will ask very few questions to my colleague, Mr. Jibril. Unlike my seniors, I am the soft one.
And I hope you are around so that you don't ask again the same questions which I have already answered.
Yes, yes, I teach law, just relax.
Mr. Jibril's statement is valid.
Yes.
I was about to make the same commentary.
The problem is his body. Cliff, make sure he eats well.
So that we can avoid repetition.
Thank you. Mr. Jibril, I want you to confirm to the Honorable Court that indeed one person of interest in the matter surrounding the death of the late Albert Ojwang is the Deputy DIG Edward Lagat.
Please repeat the question.
I want you to confirm to the Honorable Court that the late Albert Ojwang was arrested pursuant to a complaint made by the DIG, Mr. Eliud Lagat.
Yes, Your Honor.
Thank you. You also want to confirm to the court that from your preliminary investigations, the late Albert Ojwang was arrested and put in police cell, largely due to the complaint that was made by Mr. Eliud Lagat. Is that correct?
Yes, Your Honor.
Thank you. You confirm to the court that the investigations you seek time to continue with are investigations meant to assist you to unravel the persons who should be held culpable for the death of Albert Ojwang. Is that correct?
Yes, Your Honor.
Thank you. Please inform Your Honor the name of the chairperson of the body where you are coming from.
Your Honor, I think we have agreed that what I'm going to answer is what is in my avowment.
Please, just listen.
No.
This is cross-examination.
I decline to answer that question, Your Honor. It is in public domain who is the head of IPOA.
Just respond. That is your work here.
I'm responding.
Please respond. Who is the chairperson of IPOA? That is your work.
My response is it is not in my affidavit.
Yes, yes. JV, just inform me.
No.
I mean,
Your Honor, we have agreed that I will be cross-examined on what is in this avowment. The chairman of Independent Policy Oversight Authority's name or his position is not in my affidavit.
But you come from that background.
Yes. Yes.
So it's
And the council knows who is the chair of the IPOA.
I don't Please answer the question. Who is the head of the body where you hail from?
We don't have a head. IPOA does not have a
So
head.
who is the chair of the IPOA?
Yes, that should be a right question. The chair of IPOA
Answer, yes.
is one Ahmed Hassan Isaac.
Thank you. Thank you. Now, you confirm to Your Honor that there was a joint press conference on the 9th day of June 2025. Is that correct?
Your Honor,
No,
I'm not going to answer anything outside my affidavit.
Your Honor, if you permit me, just to also give context why I am asking this question. Your Honor, my learned senior and friend, Mr. J.V. Owiti, went to a very large extent in explaining the authority that was made by my Lord Professor Joel Ngugi in the Oscar Sudi case. Some of the parameters that were set by the Honorable Court were two. I think that is paragraph 24 of that authority. On the question about bad faith, the question about exceptional circumstances, and lastly, the balance of the quadruple rights that the court should look at. One of the items that we have a duty and responsibility to prove to you is to demonstrate to you that indeed there is an element of bad faith in the application that has been made before you. And that is why my questions are aimed at eliciting some of these facts based on the evidence that is going to present before you. So, Your Honor, I plead with humility that counsel, my colleague, I even suppose is my senior. My senior should just
No, I'm not your senior.
kind enough to
I'm not your
respond.
senior.
Yes, looks are deceitful, but
Your Honor. Yes. Yes.
Whatever you have knowledge, just answer it. If you don't have,
Your Honor.
You cannot argue with the court.
No. Order. Chair. Let me say this. Let me say this for the record. No, let me say it for the record. And Your Honor, protect me. The counsel who is on the floor asking questions should only answer. Learned senior should stop pointing at me. You will have your time to ask me questions if you require. The second, Your Honor, the second point I'm making here is that anything outside this affidavit, whether our chair
not within your knowledge.
is it's not within my knowledge, and please stop asking me. Anything outside this, I'm not ready to answer. It's not within my knowledge, and believe.
What is the basis? What happens to your ruling?
And after all, Your Honor, the application we are making is about an extension of continued detention of the suspect. It's not about what happened on the backyard. What you are pointing is bad faith.
That's why he was trying to lay a basis.
You just give us a minute.
Take a break.
No, we don't need a break. I think just
No, we don't need a break. We don't need a break.
just 1 minute.
That is what we are doing.
It's my intention to make it if you ask who the chairperson is, just answer if the system was in the right hand. So don't let us use that. Yes, that's what they're doing.
We are not like this. This is just calm down.
So calm down. Just answer what it is. Yona, thank you.
Let's just have the forum.
Yes.
They're not fighting. But also what matters to the system.
thank you. Mr. Jibril,
Yes.
Counsel, please confirm to Your Honor that there was a joint press conference on the 9th day of June 2025 where the chairperson of IPOA was in the company of Mr. DIG Eliud Lagat and the Inspector General of Police and others.
I'm not aware.
You are not aware. Thank you. So you have not, Your Honor, you have no information that indeed your chairperson held a joint press conference with one of the persons who's been constantly mentioned in the death of the late Albert Ojwang. You have no information, isn't it?
Your Honor, the chair attends several press conferences.
Leave those several.
So I don't follow the chair.
Thank you.
I don't follow the chair for his press conferences.
Thank you. Now, Your Honor, that is very important. You have been very honest with the court. Now, I want to return to paragraph 27 of your affidavit. Yes, paragraph 27. You have made mention that the reason why you are inviting the court to order the pre-charge detention of the suspect before court is because you have fear that he might run away from the jurisdiction of this court, isn't it?
Yes.
Have you, in your well-elaborate affidavit, demonstrated an instance where probably he was invited, he never turned up, or you have proof that he has already booked a ticket to a certain foreign land that he presented before court?
That is not in my affidavit.
No, you have in your...
No, I'm saying
Yes.
the answers that you're looking for is not in my affidavit.
No, I am asking a very straightforward question likely to attract a yes or no.
Yes.
I am asking you again. In lieu of your paragraph 27, on the question about the temptation by the suspect to run away from the jurisdiction of this court, if allowed his liberty, have you provided before this court
No.
any material?
No.
You don't have any material?
No.
Thank you. Your Honor, that should be all from me. Thank you.
The two.
I'm actually going to take very limited time in the form of 2 minutes.
2 minutes and stop it.
Then I can do 125 minutes, depending on how it's Now, Mr. Jibril, I want you to remember the testimony that you've given us just a few minutes ago, where you told us that the scene of crime was processed and released to the relevant authorities. Is that still your stand?
No, it's not in my affidavit. That's my answer.
asking you,
Yes.
You made a representation to this court and told us that the scene of crime was processed and released to the relevant authorities. Is that correct or not correct?
Now, Your Honor, the scene of crime here I'm talking
Is it
about.
correct or not correct?
The cells where the deceased died has been processed and released to the relevant authorities.
Thank you. Now, can you tell us the investigative steps that you have used to preserve the CCTV and the occurrence book?
The occurrence book is a digital. It's not.
It's a digital
It's a digital. Yes, yeah.
Is it with your possession right now?
No, it cannot be.
It cannot be.
It cannot be in my possession.
Have you
Yes.
extracted the relevant entries on that particular day?
Yes, and attached to the affidavit.
Thank you. Now, number 2, about the CCTV, can you tell us the preservation measures that you've taken to preserve the sanctity of that CCTV footage?
Your Honor, we are a team of investigators. That aspect is being done by the forensic team.
So you can also confirm that the CCTV in itself is not with the police station. It is with the forensic team.
No, what was extracted is the only DVR. But the entire, you can't carry a whole screen.
It's okay. That's what I want you to tell me.
Yes. What was extracted is only the DVR.
Yes.
Yes.
So the DVR that records the events of that fateful day is the forensics team.
Yes.
Thank you. That's all.
Thank you, Your Honor. Hi, Jibril.
Good morning. Good afternoon.
Good afternoon. I kindly allow me to ask you just 2 questions. I want to take you to paragraph 6A. Where you have said the DPA received a complaint from the Deputy Inspector General of Police. Confirm?
Yes, Your Honor.
Was it an oral complaint or a written complaint?
It was a letter. A formal,
It's a letter.
yes, a letter to the
Have you
DC.
provided that letter to this court?
No, it's not attached here.
It's not attached here.
Yes.
Thank you. Kindly go back again to paragraph 7, where you say the respondent was arrested and under the Langata police station, OB number 50.
Yes, yes, Your Honor.
Who booked the respondent at Langata police station?
The booking was done by myself.
It was done by yourself.
Yes.
Thank you. Are you aware of the law governing the booking of a person at a police station?
As per the IPOA Act, yes.
As per the IPOA Act?
Yes. And the regulations.
For instance, are you a police officer or a former police officer?
I'm not a police officer. I'm an
Have
IPOA
you not been
employee.
a police officer?
Yes, I've been a police officer.
You have been a police officer?
Yes, Your Honor.
Thank you so much. Paragraph 21. Now, paragraph 21, Jibril, you're saying there are co-conspirators. Confirm?
21, yes.
Do you know the co-conspirators by name?
That is part of investigations. I cannot reveal here.
No, I'm just saying, do you know by name, not their names. Do you know them by name? Because you have said there are co-conspirators. Do you know them? Not by name.
She's not asking you to name them.
Counsel, this is what I've been saying.
Relax, Jibril.
Let me answer her. The thing is,
Can you help me with it?
yes,
Just say yes or no. Do you know the co-conspirators?
the matter is under investigations.
Yes or no?
As of now, no.
You don't know them. Thank you so much. Number 25. You have said that there was the murder of the deceased was planned, executed, and their attempts to cover up. Do you know the people who are trying to cover up the death of the deceased?
One of them is your client.
Do you know that with certainty?
Yes,
Have you provided evidence to that effect? Or
No.
the attempt to cover up?
it's under investigation, but not attached to this affidavit.
You have said that, yes, you know the client is one of the people trying to cover up. My question is, have you provided evidence that he is one of the people who is trying to cover
As of
up?
now, no.
No.
Yes.
Thank you so much. Thank you, Honor. That is the
I think, Your Honor, that will be the end of the examination of the witness. We will lay now, if he's, once he's discharged, his Keaton will lay the basis for our next line of approach.
Even we would like a few minutes of re-exam, because that follows cross-examination. Mr. Jibril,
Yes, Your Honor.
my work is to calm you down completely. And make you
No, actually, I'm calm and composed.
I'm glad. Thank you. Now, I will limit my questions back to the contents of your affidavit, many times by paraphrasing.
Okay.
What is the basis of your request for detention continuing in one line?
To complete my investigations.
On a scale of 0 to 100%, how much could you, by approximation, attach to your investigations up to now, on a scale of 0 to 100%? Doesn't have to be accurate, approximation.
49%.
49%. So I can mathematically say this as direct evidence that you're saying there is 51% of investigations to be done.
Yes, Your Honor.
So that there are questions about who is in charge of the cells, who is in command of the station. Do those questions relate to the remainder of your investigations?
Yes, they do.
Now, to ask another direct question, are the questions from the defense some of the things you need to investigate to complete your investigations?
Yes, Your Honor.
Thank you very much, Your Honor. I'll hand over to Mr. Johnson.
It's just one question, the examination. You have been asked whether you have attached any document relating to, I think it was paragraph 6A, some paragraphs in your affidavit, whether you have attached anything to show that even the respondent is a flight risk. Why do you need the respondent in custody? Is there any reason why you have not attached?
Yes, Your Honor. The reason I have not attached what I've collected so far, the 49% I'm talking about, is that it will jeopardize the investigations. And this is actually to protect the integrity of the investigations. That's why we cannot divulge much.
Thank you very much. I believe that is all from our end.
Thank you, Your Honor.
I'm glad that you confirmed that you were calm.
Yes.
Thank you.
Then allow the next phase of our team led by Kit. You have been procedural, check out animation.
It depends how you take
As we are in, we are only asking this for the benefit of
how many will be submitting.
4.
This
There's
is
Kiton, there's Langat, there's Tutsi.
you okay with that? You need some break.
We are fine. We are fine. Proceed. The only thing that we'll be asking is there something that has been filed so that it can be served, or it's an oral.
Let's see what they will have.
Yes, very well.
If there's anything you can.
We'll serve you with authorities, simply. Our team serve the state with the whole. Is that it?
So just like brevity, because this issue is involved in itself. So just brevity, just direct to the point here.
Your Honor, for the record, I remain Felix Keaton, and also there's also another additional attorney at law, Vincent Yegon, also is part of the defense team.
Present, Your Honor.
Your Honor, we reiterate that we vehemently oppose the motion application dated the 16th of June 2025. And from this motion, Your Honor, there is only one salient issue for determination. That is whether there are compelling reasons for pre-plea, pre-trial, or pre-charge detention has been settled in law, is well settled in law.